Hi, I'm Miguel Hernandez, and I want to talk to you a little bit about my practice, the actual practice of running a law firm. Well, first of all, I started in the public defender's office many years ago. And when I say many years ago, I think the dinosaurs are still roaming the earth. I spent 3 years in the public defender's office, and then I left and joined two gentlemen, and they had a private practice, and they needed somebody to handle criminal cases, and I fit the bill, so that's what we did. We did that for about a year, and our practices didn't work out together too well because their practice was very paper heavy practices, and the secretaries that we had were very burdened, or they had so many things to do that my cases, the criminal cases, when I had to file a motion, write a motion, or whatever, I'd give the motion to the secretaries, and they'd put it at the bottom of the civil material, and it took a long time to get to mine. And so I was very anxious, and I ended up writing my own files, motions, this sort of thing after a while. And so when it didn't work out too well, I went into private practice by myself, solo practice. Well, even that has a lot of challenges, and it did. First of all, you have to have employees you can really work with, and I ended up getting a secretary. I went through several secretaries, and they didn't work out too well. Then I came up on my third secretary, and she became the best secretary I ever could imagine. She became so good at her job that I decided that she needed to be a paralegal and do extra different type of work to help me. So then we had to get a secretary because she couldn't be doing the normal secretary work that that I would rely on. I depended on. So we had another one. So we were lucky. We got a very good combination of workers in this office. Myself, and my paralegal, and my secretary. And we worked like a team. And it had a lot of challenges, but overall, these employees and myself, we really worked well together. The Having a private practice is more than just having a case and going to court. There's a whole bunch of other things that are required. You have to have workers' compensation. You have to have insurance. Yeah, you have to have you have to do your taxes, your tax forms, fill them out, and file them on time. So that's a pretty big order. So having a practice is I discovered was very hands-on type of thing. I had to be involved in all of that. Then then there's a special thing you have to worry about, or not worry about, be concerned about to do, and that is a client trust fund. Clients will deposit money, and it's not yours immediately until you earn it, and then you have to write a check to yourself from the client's trust account, and you have to make sure that everything balances because I, I'm I won't even let a nickel discrepancy occur, and make sure that the client trust fund is always up to date and the client is always taken care of. And then at the end, if the client has some money left in their trust account, but they still owe you some money, you cannot take that money and apply it to the, the unpaid attorney fees because it's their money. So you give them the option. They can write a check and return their money to them, or they can allow me to apply that money towards what they owe. Most clients ex, uh, exercise the option to have the money uh, applied to what they still owe, so that they won't owe anything. But sometimes clients want the money. Let's say there's several $100s or maybe a couple of $1,000s left. They want it for immediate things that they need, and but they continue paying on the attorney fees. So that's okay. But you have to be very careful with the client's trust fund, because the state bar is very concerned about this, and they will not let attorneys dip into client trust funds unless they've earned it, or unless they've had authority to apply it to client fees. So what's involved in all of this? Well, number one, it's called confidentiality. your client comes to you and they tell you certain things, you cannot repeat it. An attorney cannot repeat a client's statements, information, unless they authorize them to. Like, I cannot discuss it with anybody at all. But if there's a witness who knows something and the client is saying this happened this way and that way, and they want you to explain that to the witness, they have to give you authority to do that, or to their relatives who come in and ask about the case. You cannot discuss it with the relatives because that is confidential and cannot be discussed in other fashions. And the word trust fund and that sort of thing is very important because the word trust is in there. When you have a client, you have to gain their trust that you're going to look out for them and you're going to do the very best you can for them. You don't have divided interest in seeing something else. You shouldn't represent two clients on the same issue in the same case uh, at one time. Oh, there's exceptions. You can get their waiver of that conflict of interest, but it's not a good idea to be doing that, at least not very often, because sometimes issues will come up where they differ in their approach, and then all of a sudden you're stuck. Who do you choose? Well, you can't. That's why you should avoid uh, having conflict of interest in multiple clients, two or three clients. Every now and then you'll have a client who's very unmanageable. They want to do things their way, and they know better than the attorney, and it can be very frustrating. So what I do is I tell them right up the beginning, it looks like you're not going to need my services, so you really should get another attorney. Sometimes they say, no, 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 I'll do what you say. And so it's a joint effort really in defending somebody. They give you the information that they trust you with, and you do the best you can with it. But if they want to run the case and do everything in the case, or most things, as an attorney, you can't allow them to do that. I don't. I say, look, if you want to run the case, you're more than welcome to run the case, and I could step out of the case or not even get into the case. So you have to be able to know when a client's going to be unmanageable. The lure of getting paid right up front, it might be great, and the client wants to hire you, but you can see by their demeanor and what they're saying that they want to run the boat. They want to run the show. And I tell them, look, there's only one person who can operate this bus. I'm the bus driver, and you're the passenger, and I'm going to get you to where we need to get to. If you can't accept that, then you have to be the driver, and then you have to either get another lawyer or do the case yourself. Most clients, when you give them that option, will settle down and let you do it. Other clients won't, and they end up leaving and not hiring me, which is okay. I don't want to be representing somebody when they want to run the operation, and I'm just sort of along for the ride. I can't do that because things will go off the rails, as they say. In a practice, sometimes people advertise and advertise a lot. And when I first started practice, I did not do any advertising at all. I got people always asking me to advertise. And one time I did. I advertised for a year with this one company, and I didn't get one client. And then the person responsible for the advertising came and wanted to renew the advertising. I said, I didn't get one client based on these ads. So I didn't. And then I get a call from, let's say, the radio wants to put me on the air, will get me more clients than I can possibly get. And I go, no. I go, I'm getting plenty of clients, word of mouth. My reputation is spread, and people come to me because they've heard of me. I've helped one of their relatives or their friends, and they want to hire me. And so I don't need any advertising, because I told one advertiser, so I would have to nail the door shut if I had as many clients as you're saying I'm going to have, because I have plenty right now. So throughout most of my career, I didn't have any advertising at all. Well, now times change. There's so much competition out there. My son, who joined me in practice, a young man with young ideas, said I have to advertise on the internet. I have to have a web page, et cetera, et cetera. And so now we do advertising. I let him handle it, but he doesn't go overboard. I'm headed towards retirement. I've been doing this for almost 50 years, and I'm looking forward to retiring. And my son's been with me a good 17, 18 years as a lawyer, and his name is Jevin Hernandez, and he's done a great job being my partner, and he's really lightened the load for me. And so when I retire, I'm turning over this building, I'm turning over the practice and everything. He's going to be the sole proprietor of this business. It's called the Hernandez Law Firm, and it means him and me, but now it's just going to be him. But I'm happy to see that, and I'm happy that he stepped up and done a great job. So thank you very much for listening to me, and hope that I can talk to you again soon.